Hi, I'm Sam Brotman. Our law firm has been getting a lot of questions surrounding the Employee Retention Tax Credit, in part because of what's going on in Congress right now and what's going on with the IRS. Naturally, the IRS hasn't been the clearest in communicating what the future of the credit is, and so the ambiguity is causing a lot of questions and it's causing a lot of fear. We've been getting questions from our clients, from prospective clients, from the CPA community, and from the professional community at large. As such, I wanted to take a few minutes to record my thoughts on video. This video is current as of the day it's shot, February 2nd, and although things may change in the future that may impact what I think, I'm going to try and be as clear and as transparent as possible with what my perspective is in terms of what may happen on the credit. There's nothing inherently wrong with the credit itself. In fact, the credit on some level was successful because it got government money into the hands of businesses that were most impacted by the COVID-19 pandemic. However, the administration of the credit has not been without its share of problems. Perhaps the biggest problem is that the government significantly underestimated the demand and the ultimate cost of the credit. As knowledge of the credit grew, mostly due to ERC promoters or ERC credit mills, public demand of the credit reached a fever pitch. People were made all sorts of promises about being able to get free money for the credit. And the problem is that a lot of these ERC promoters didn't have the technical knowledge required to analyze whether or not people actually qualified for the credit. So many businesses who are completely innocent in this process were told things that weren't necessarily true. The problem with the Employee Retention Tax Credit is that the IRS received a surge of applications, particularly in the summer of 2023, that ultimately led to the issuance of a moratorium. That moratorium is still ongoing, and as a result, the IRS is not processing any new applications until the moratorium ends. What the IRS has chosen to do instead is it's taking all the applications that it has received and is in process of digitizing them. The reason the IRS is digitizing the applications is so that it can analyze them into buckets of risk. It is presumed that after the IRS analyzes the applications and decides which ones are most risky, it will start to seek enforcement action against those taxpayers and promoters that it feels may have taken advantage of the system. Because of the amount of money that is involved, I do want to stress that these enforcement efforts may be of a size and scale that we have never seen before. So those people who committed bad acts during the Employee Retention Tax Credit period may have some things to answer for. However, I equally want to emphasize that many taxpayers have nothing to worry about. Those taxpayers that used a qualified CPA, qualified tax attorney, or other tax professional and went through some level of due diligence in applying for the credit generally needn't fear anything from the IRS. The IRS has limited resources to pursue bad actors in the space, and so as a result, the IRS will need to pick and choose whom it goes after. If you take the bad actions during the Employee Retention Tax Credit on a sliding scale, the people towards the end of the scale are people who committed overtly fraudulent actions. So these are the people who made up businesses or made up payroll and filed absolutely fraudulent applications. Maybe slightly to the left of this group of people are the promoters who just blanketly submitted all 6 quarters for the credit without doing any sort of due diligence. And they did so largely to collect large contingency fees that the government is worried about. Perhaps slightly to the left of this is businesses who may have some basis for filing the Employee Retention Tax Credit, but ultimately wouldn't qualify under the definition of the law. And then, slightly to the left of that, you have the rest of people who did have a valid credit claim and equally shouldn't have anything to worry about, except for the fact that they may have used a promoter or they had problems with their employee retention tax credit application in some way, shape, or form. And so you see, not everybody is in the same position. As a result, when the IRS issues statements or general guidance concerning the credit, depending on which bucket of taxpayer you may be in, that should frame how you view the advice that you're being given. My point is that in the future, as you hear things from the IRS, as you hear things from the national news media, as you hear things from the professional community, that guidance is tailored towards a very, very wide audience. And depending on where you fit on the scale of people, you need to interpret that differently. Taxpayers, for example, in states that had much more stringent government orders, like California, are not in the same footing as those in states that had less restrictive orders, like Florida or Texas. So the point is, take everything you hear with a grain of salt.